The Obama administration is joining a chorus of civil rights activists in defending a landmark section of the Voting Rights Act, now being challenged in the U.S. Supreme Court. Just days before the court is set to hear arguments in the Shelby County, Alabama versus Holder case, President Obama shared his views with SiriusXM Radio's Joe Madison.
And people could keep coming up with new schemes each election, even if ultimately they were ruled to violate the Voting Rights Act. It would be hard for us to catch those things up front to make sure that elections are done in an equitable way.
The Voting Rights Act has been hailed by top civil rights advocates like Barbara Arnwine.
Since that act has been in effect, thousands, I'm not talking about 1,000, 2,000, I'm talking about tens of thousands of voter changes and procedures have been stopped because they would have discriminated against either a person of color, meaning somebody who's African American, somebody who's Latino, or somebody who is Asian American or Native American, which are the groups that are covered and protected. But it's basically to make sure that nobody is discriminated against it.
But now a major component of that law, known as Section 5, is being appealed by Alabama's Shelby County. That state, along with 8 others, must get permission from the federal government before changing their voting laws or maps. Hans von Spakovsky, a former senior official under George W. Bush's administration, supports Shelby County's challenge. He disagrees that overturning the law would turn back the clock.
There's no evidence whatsoever that things will go backwards. And in fact, they can't go backwards because of the other parts of the Voting Rights Act.
AP Supreme Court reporter Mark Sherman reports the law is set to expire in 2031 and was never designed to be permanent.
What would America have to look like, in essence, for this provision to no longer be necessary? There's not a very clear answer, other than what the civil rights community says, which is at the time at which there's no longer persistent efforts to discriminate against minorities, then there'll no longer be a need for the law.
The Supreme Court will hear oral arguments Wednesday. A decision is expected in June. Matt Small, The Associated Press.